Hello, my name is Romy Borowski and I come from Munich, which is a city in the south of Germany where I grew up and I spent most of my life. The German judicial system has always been of interest to me as I've always been very fascinated by the detail and the structure of the legislative process. I've always found the idea of understanding such a complex legal system and knowing how to navigate it very enticing, which is why today I would like to take the time and explore the laws of ownership and property in my country, as they have been laid forward by the BGB, the Bürgerliches Gesetzbuch, and the German Basic Law, the Grundgesetz. Germany is a federation with 16 partly sovereign states. They're called Länder in German, which means that technically those laws could differ statewide. However, due to a much more centralized nature of the German government as opposed to, for example, an American one, legislation tends not to differ extremely from state to state. Within the scope of private law, Section 903 of the German Civil Code equates ownership to the rule a person can have over a subject, which is also the core definition of what ownership really is. This means that a person is entitled to do with his or her own ownership or property as they please, and they must be excluded, and others must be excluded from influencing so long as the laws and rights of those parties do not conflict with the laws of the owner. A broader understanding of this concept is explored in the German Basic Law in Article 14, which defines property as well as inheritance as a fundamental right. This by this nature, property is considered to be all the assets which a legal system assigns to one person. The Basic Law, therefore, on one hand considers the property laws to represent the citizen's right for defense against the state, and on the other hand, it obliges the legislator to create, shape, and to protect the property rights. The basic right, thus, protects the basis for independent life and a free market economy. Historically, the immediate forerunner of property laws applied today is Article 153 of the Weimar Constitution. In German, it is called the Weimarer Reichsverfassung, which showed great parallels in content to Article 14 of the Basic Law. According to this, ownership was guaranteed, specified, and restricted by the legal system. The property guarantee, however, was very quickly eroded under the rule of the National Socialists, the Nazis, who accessed the property of private individuals, especially members of prosecuted groups at the time, at any point of time of their will. As a part of the development of the Basic Law, the Parliamentary Council based itself on the guarantees of the Weimar Constitution. As a little bit of context, the Weimar Constitution, as it was written at that time, was considered to be one of the most democratic constitutions ever written on paper. It failed for much other reasons. Since there is a very close factual connection, however, between the property and between the inheritance law, they were both bundled into an article that I've mentioned before, the Article 14. It has also remained unchanged ever since it was enforced. Lastly, another regulation that protects property and relates the legal situation in Germany can be found in Article 1 of the first additional protocol of the European Convention of Human Rights, the ECHR, which reads that every natural or legal person is entitled to the peaceful enjoyment of his or her possessions, and that no one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law and by the general principles of international law. So according to this case law of the Federal Constitutional Court, the ECHR has an indirect effect on the German legal system, as German law is directly influenced by the ECHR, and the interpretation of German law therefore is too. The regulatory protective guarantee, which protects the citizens from sovereign interference in property, is called the Eigentumsgarantie in German. To this end, what it does is it guarantees a sphere of freedom that sovereigns may only intervene under very certain conditions. This sphere can be defined as the protection area, the Schutzbereich. If the sovereign intervenes and it cannot be constitutionally justified, then the guarantee of property is violated, so that the interference becomes unconstitutional. Jurisprudence, however, manages to differentiate between the personal and the material protection of those fundamental rights. The personal protection area determines who is protected by the basic right, and the objective area of protection determines which freedoms are protected by the fundamental rights. That is the nuisance there. To this extent, the property rights of individuals, therefore, are not only from third parties, but also from governmental interventions. In contrast to that, the prevailing view is that public property is not very well protected at all under the Article 14. There seems to be a lack of risk situation typical of those fundamental rights that justify the application of the fundamental rights to them. An example of that is a municipality which cannot invoke Article 14 of the Basic Law to prevent a nuclear power plant from being built on the vicinity of their property. Therefore, this shows that a blanket of denial of protection does not take sufficient account of the fact that in special cases a comparable need for protection can and must be observed. And in addition to that, according to the ruling of the Federal Constitutional Court, the Rechtsprechung des Bundesverfassungsgericht, the scope of protection of that property guarantee includes all rights that the legal system grants to the individual for exclusive use in his or her favor, which we've gone through before. The scope of protection of the property guarantee does not result from the Constitution alone, but it is shaped by a legislator. The prevailing risk at that is that the legislator will design the property system as sparingly as possible so that the article is as seldom as possible in opposition to sovereign interference, which obviously would be very, very problematic. This risk of abuse is prevented by the guarantee. Abuse is prevented by the guarantee of Article 14, which states that an inviolable core area of property that the legislator must provide. Property within that article is, on one hand, the property of ownership, which Article 903 describes as the legal power of disposal of a thing. So if there is a sovereign interference, it is lawful if it is constitutionally justified. Since Article 14 assigns the legislator the task of defining the content and limits of property and allowing expropriation, it makes the guarantee of property subject to a legal reservation. Therefore, ownership can be restricted by law. To Article 19, paragraph 2 of the Basic Law, the legislator may not interfere with the essence of According to Article 19, paragraph 2 of the Basic Law, the legislator may not interfere with the essence of fundamental rights. These fundamental rights include the right of disposal to the right holder, the guarantee of substance, and the principle of private benefit. To conclude all that, the everlasting nature of the fundamental right is strengthened by the protective property laws that we have explored. While governmental intervention is still possible, legislation works in opposition to that in protecting the individual rights to ownership. In Germany, this has been a very interesting subject, and to me personally as well, very interesting subject to delve myself into, as the historical events portray the continuous change of legislation throughout political turmoil, throughout war and country separation.